Hello, hello, hello. You here once again with David Jose, Volume 2. Did David Jose teach Karen Fann? Did I open up the door to show her how to use the law? Did I purposely block the courts, block the DOJ, block anyone else from being able to interfere with the people's business? Yes, I did. I hid it, guys, because I knew bad actors like we see with Joe Altman and Professor Clements today, they would try to block me and stop me from actually getting the word out, the truth out of what we're doing. So here's my shirt that I'm actually wearing in the video a year later. You see I got a full beard with scraggly hair. It cannot be at the same time. The background is different, and you can see that it's when I first had some pictures on there on the wall, something put up, right? So guys, this goes to show what we did with Karen Fann. This goes to show that we were the first to show her how to use the law and why. And guys, this is the same law right now that will stop them from being able to prosecute Trump, because I also set up something in the law with two people in order to make sure that President Trump have full obligation to make sure that he did what he did after 2020, to pick up ballots, to look into the situation and investigate, and nobody told you. You know why? Because nobody knew. All right. Now I got a whole bunch of evidence, a whole bunch of information, enough to write a movie or make a book. It will blow your mind. But check into the video and tell me in this next 10 minutes, can you see that I taught Karen Fann valuable information? And this is why the DOJ that we put on notice in Perkins Coie, they knew, don't go after her. Let's see the real law, y'all. Let's see that real smoke. Hello, Karen. This is Dave giving you another video just for you to be able to check out and look at some of the things that you might be able to do when it comes to if the federal tries to interfere with your work that you have to do as a legislative body member. One of the things I want you to remember is in the case, the judge, I think his name is Martin, he kept saying how there was no substantive evidence showing that the other side had the ability to come before the court and pretty much force a TRO. So what they needed to do was prove that there was some actual harm or some actual threats to the people. Now, on the other side, you guys were able to show that you had the authority to do it as the legislature. But I want you to think a little bit deeper about this, because this is true in the federal constitution and in the state constitution. First of all, you have an oath that you swore to uphold. And when you think about the hierarchies of law, there's going to be the statutes, right? And what you have to understand is that as the legislature, when you create statute for the lower entities that are below you, the political subdivisions and such, those statutes that you create are created to bind them and tell them how to do things. Those statutes are not created to bind the legislature, who has plenary power to be able to deal with all the issues necessary and proper to carry out the authority and the duties and obligations that the people gave you. So what I want to do is go through some of the things in the state constitution that you swore to uphold and that every other entity in the state swore to uphold, so that you can understand where there is an obligation that you have based on contract. So the Constitution of the state is a trust indenture. If you need me to explain that to you, I'll break it down. But it is a trust indenture where it tells the duties that you have as a trustee, someone who is working for the people. So let's go through some of these things really quickly. So what we're going to look at is Section 1. A frequent recurrence to fundamental principles is essential to the security of individual rights and the perpetuity of free government. So the people have the right to come to you and petition you, give you notices, give you affidavits of what it is that they desire, which you have done an amazing job in. So when you're dealing with your fight against the government at all, let them know that you swore an oath to the people that they can come to you and tell you what they desire. Put it on the people, Karen. Let them know that the people demanded and requested that they're able to know who had the most legal votes. Now here's another one. Article 2, Section 21. All elections shall be free and equal, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. Now what we got to understand is that part of the right or the power of the people in elections is Article 7, Section 7, which allows us to know who had the most legal votes. Article 7, Section 7. In all elections held by the people in this state, the person or persons receiving the highest number of legal votes shall be declared elected. So realize there is no process in the state that shows that every vote was counted to see which ones were legal. Now, realize that for you and your attorneys, this is important. Text of Section 32, this is Article 2. The provisions of this Constitution are mandatory unless by express words they are declared to be otherwise. Well, there's no words that can get rid of the Constitution unless the people made it. So the provisions of the Constitution that are here that you swore to are mandatory that they be done. No court, no official can remove your obligation that you have. Now, how do we know that? Article 2, Section 2. All political power is inherent in the people, and governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. So realize, Karen, that the people have an individual right to have everything that is demanded in the Constitution. There is no way to get around it, which means you have an obligation to the people by contract. You can open up your contract called the Constitution in the court, and it is based on the common law, and there is no higher standing. So, Karen, I want you to see Section 25. This is really important. No bill of attainder, ex post facto law, or law impairing the obligation of a contract shall ever be enacted. Now, understand that you have courts of record that are moving off of statute and code. Off of common law. And then you have the courts that are legislative tribunals. Those are the ones that are fighting over things like the statute, which you guys created, or procedure manuals and things of that nature. Well, when it comes to the common law is always higher when it deals with the necessities of the people. And these statutory issues are always lower. But here you see that they cannot make a law to interfere with the obligation of contract. Now that gets really deep, because if somebody's trying to bring an argument to the court by statute, yet the legislature has a direct contract with the people and you are forced to follow the Constitution and follow your obligations, nobody can remove your standing and what you do by necessity to protect the rights of the people. So when you have different things put in the Constitution by the people expecting you to take care of it, you have what is a fundamental principle called being necessary and proper. If we give you a order or a directive in the trust indenture called the Constitution, then we are also giving you the ability to do those things which are necessary and proper to deal with what we're asking you to do. Also, let's see in Article 2, Section 3, Part B, to protect the people's freedom. You have a duty to protect the freedom of the people. And to preserve the checks and balances of the United States Constitution, this state may exercise its sovereign authority to restrict the actions of its personnel and the use of its financial resources, right, to the purposes that are consistent with the United States Constitution. So now understand you have the power to use initiative, referendum, passing a bill, or any other legal remedy. You have a lot of choices. In order to protect the people's freedom, you have the sovereign authority to restrict the actions of government personnel trying to work with the Fed to enforce, administer, or cooperate with any federal program or action. So see Section C, if the people or their representatives, so either one of us could do it, we as the people or you, exercise their authority pursuant to this section, the state and all political subdivisions of the state are prohibited from using any personnel or financial resources to enforce, administer, or cooperate with the designated federal action or program. So realize we can do that with any program. So Karen, blame it on the people. Let them know that we, the people, asked for this. If you need to let them know that we gave notices or the people stepped in to ask you to take action and we did that based on our contract we have with you, then there is no court in this nation and no entity, even the Fed, that can step in between the obligation of your contract. Okay, so now even notice in Article 1, Section 10, Clause 1 of the United States Constitution, you see where it says no state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. So you guys can't write a law to interfere with the obligations of contract. So it's impossible that any court or any entity could also interfere with the obligation that you have by contract. So it is impossible to be done. So you guys are all the way in the clear. You have an obligation based on the Constitution. Use it, stand on it. Thank you for all that you do, Karen, and for pushing so hard. Please continue to be strong. Do not be influenced by the wicked and bad things, but continue to stand, and we will stand with you. If you need anything from us as the people, let us know. We will stand with you. Have a good day.